sure that we have time for that. So let me begin by, first of all, thanking all of you for coming tonight. My name is Faiza Patel, and I am one of the co-directors of the Liberty and National Security Program, which is the part of the Brennan Center that's been working on this issue. Now, what we're talking about tonight is a very important topic, and one that has, for the most part, kind of flown under the national radar. The move in a number of states to enact bans on the use of foreign law in their courts. Now, you might recall that a few years ago, bans on Sharia law were all the rage. The fact that Muslims make up a minuscule proportion of the American population and the likelihood of Sharia becoming the predominant system of law in the United States was precisely nil, but that didn't seem to mean much to those who pushed for these bans. When the federal courts in Oklahoma overturned a blatantly unconstitutional Sharia ban, the folks behind these bans reformulated them into something that is called foreign law bans. This new wave of bans purports to prevent courts from applying foreign law when it contradicts state or federal constitutions. It almost sounds logical on its face, right? Our courts shouldn't apply foreign law if it contradicts our Constitution. It's actually not quite that simple. U.S. courts have been applying foreign law for decades and have developed tools for ensuring that no foreign law that violates public policy is applied in our courts. But this is not the same as requiring foreign laws to comply with every detail of our constitutional structure. For example, states sometimes require jury trials in civil cases. That's very rare outside the United States. But a foreign law ban could invalidate a judgment in a civil case that was decided by a judge because it doesn't comply with the state constitution. These are the types of problems that foreign law bans create, and you're going to hear more about them later. And then, of course, there's the true purpose of these bans, many of which are aimed at stigmatizing Muslims. While foreign law bans apply to all non-American law, it's no secret that they are targeting certain types of law and certain types of people. And you'll be hearing more about that tonight as well. Now, to discuss this issue, we have a truly stellar lineup, and I'm going to start with our keynote speaker today, who is Judge Robert Henry. Judge Henry is currently the president of Oklahoma City University. But prior to that, he served for many, many years on the 10th Circuit Court of Appeals, which covers Oklahoma, and was its chief judge from 2008 to 2010. Now, the 10th Circuit is the only court in the U.S., the only appeals court in the U.S. that has considered the constitutionality of a Sharia ban. In the case of Awad, it found Oklahoma's version of the ban unconstitutional. So, Judge Henry brings a very unique perspective to this issue. He also has deep expertise in international law issues and has served as the inaugural chair of the American Bar Association's Middle East North Africa Council and was an advisor to the ABA's Middle East and North Africa Law Initiative Council as well. So with all of those experiences under his belt, he can give us a really interesting perspective on this issue. Judge Henry.
Well, thank you and welcome this afternoon. Oklahoma's favorite son is Will Rogers. And I just recently spoke at the 75th anniversary of the dedication of his memorial in Oklahoma. And one of the lines that I quoted, if we have time later, I'll tell you a couple of other things that Will said about religion, including the piece that he wrote attacking his old friend William Jennings Bryan for criticizing a teacher for teaching evolution in Tennessee. The piece was entitled, "We Might As Well Be Monkeys If We Act Like Them." Will said something that I quoted last week that may be relevant. He said, "Once ignorance gets started, it knows no bounds." About a year ago, I was invited to speak to a group of retired Oklahomans who live at a place called Epworth Villa. And Epworth Villa is a Methodist retirement home. Oklahoma City University is loosely affiliated with the Methodist Church. And a number of these folks at this home are donors of ours and wonderful people. I like elderly people, and I agreed to speak to them. We had a huge crowd. They had to bring chairs in. And I think it might have been because I told them what I was going to talk about was political wit and humor of Oklahoma. And Oklahoma is a place, a lot of southern places are like that, like this. It has an amusing political culture. We say there's always an aroma in Oklahoma around election time. And, one of the leading racists of the modern South, a guy named Alfalfa Bill Murray, was the architect of our Constitution, and it was the longest Constitution written by the pen of man at the time it was passed. Later, Oklahoma, by the way, you proud New Yorkers, we had more socialists by number than you did in Oklahoma. And the leading socialist, Oscar Emringer, said that politics was the art of taking money from the rich and votes from the poor on the pretext of protecting each from the other. But he also pointed out that socialism grows where every other crop fails. And that's why we had a lot of socialism in southeastern Oklahoma. Nothing else worked, and so people were for just about anything. The socialist roots were very shallow, and they vanished. But anyway, I had this large crowd, and as I came in, they were still bringing chairs in, and this sweet elderly woman handed me a folded piece of paper, and she said, "Please, Judge Henry, if you get time at the end of your speech, would you answer this question?" Well, I couldn't wait to see what the question was. And the question was, what do we have to fear from Sharia law? And I thought, how sad is this? These sweet people here in this retirement village, and someone has somehow convinced them that there is something to fear from this. What was it Stephen Colbert said the other day? Well, anyway. So I did finish my speech, and then I answered it. What I could have said is what you really have to fear is some things from this misguided response to Sharia law. Some problems with Establishment Clause, free exercise, and equal protection violations of our Constitution, some violations of freedom to contract, some disrupting of international law and international business and collection of judgments, some messing up of our choice of law doctrines that have grown for hundreds of years in America, some messing up of international marriage and family law conventions, who's married and who's not, and violation of the separation of powers. There are lots of things that come from the proposed solution to this non-existent problem. But instead, I just said that you really don't have anything to fear. And I tried to explain it. Because, as Noah Feldman has said repeatedly, Sharia law needs a press agent. It has received the worst press of any doctrine imaginable. People think it does all sorts of horrible things, when really it is a way. That's what it means, a way, or the way to water. I find it interesting, Wallace Stegner some years ago gave a lecture at the University of Michigan on the West, and he said the defining characteristic of the West, the defining character of the West, is aridity. Lack of water defines everything in the West. Well, lack of water is important in the Arab world too. And when water is found, that water is better if it's not stationary, if it's moving, if it's evolving, if it responds to needs and interpretation and so forth. And so Sharia law as it exists today, and one of my colleagues reminds me that this is a modern creation of the nation state, but Sharia law is like canon law. It's different in every country that has it. Sharia law in Morocco, where I've been many times, is hardly recognizable. In Afghan Taliban, it was as harsh as it could possibly be, perhaps. And in other countries, it's a mix. So there is no universal pandemic of some Sharia law that's going to come and engulf. It's a different sort of thing. And then it's perhaps its purest use. It's not, in one sense, legal at all. It's at least in terms of the secular laws that we use. But where Sharia law has had the worst of its press, the worst need of the press agent, is in that area of law known as criminal law. Sort of a lex talionis idea. And remember, lex talionis was invented in the Torah, in the Jewish scriptures. An eye for an eye and a tooth for a tooth. Although the rabbis made it clear that they never interpreted that literally. In their commentaries, they point out, what if a person had only one eye and he blinded someone else? How would that be just to blind him? Rather, the lex talionis was a call for money damages. And it was, I think, the greatest step forward the law has ever taken. I can't think of a step greater than that, because it used to be, you steal my cow, I burn your village, kill your daughter, and sow salt in the ground. And the Lord says in these commandments, no, wait a minute, the punishment has to fit the crime. And that's a very, very important thing. So, as I pointed out to these wonderful elderly people in Oklahoma, when you commit a crime, you don't get to choose the criminal law that you're prosecuted under. If you did, you wouldn't choose Oklahoma's criminal law. We incarcerate more people longer than anybody else. So if you had a choice and could choose criminal law, Sharia law would help you. Even in Saudi Arabia, it would help you. As one of my Egyptian friends once told me, he said, I can conceive of a possible way where I might get 39 lashes if everything came out right. He said, I can steal 3 DVDs in California and get life without parole. He said, which one would you take, Judge Henry? Well, I'd get my doctor there and take the 39 lashes. I know what life without parole in Oklahoma means. So you don't get to pick the criminal law. The criminal law is there, and it will be applied. So you don't have to worry about hand chopping and even the 39 lashes. All you have to worry about is if your grandkid steals 3 DVDs. So you also, similarly, don't get to choose tort law as a rule. There are choice of law clauses and provisions that allow us to determine what tort law should apply. And so there's not a great chance of Sharia law that, and of course if the law is contrary to public policy, it's not going to be applied. In terms of contracts, that's the whole point. You get to choose the law when you have a contract. We have freedom of contract. And as my very conservative friend Eugene Volokh says, American law really doesn't look to why people do things. They don't look to the why behind prenuptials or wills, or they look to the formality. Was it done properly? And so in contract law, it's part of American law that you have freedom of contract. Thus in Oklahoma, I happen to serve on the board of Oklahoma's largest corporation, Devon Energy. Devon Energy is about 40% Canadian. A lot of contracts that Devon uses have Canadian choice of law clauses. Now, I have to tell you, I think Canada is our greatest friend, our best friend. 6,000 miles of undefended border. But they are foreign, and their law is foreign. They had their chance to join us in the revolution, and they didn't. I think they probably made the right decision. But anyway, so it's a part of American law that you get to have freedom of contract. So it was discouraging to me, and I explained, this is the first time I've ever really been able to answer this question, because I stepped down from the federal bench. I was unindicted. I stepped down from the federal bench, and one of the last cases I wrote was a case where I extended the same protection to Muslim inmates with respect to their diet in the prisons that we did to Jewish inmates that, to my astonishment, the state of Oklahoma contested. Anyway, this has been kind of a long battle. Well, now it's been mixed, as our introducer told us, with the foreign and international law. Now there is an argument, and Justice Scalia is one of the leading advocates that foreign law shouldn't be utilized in various cases. And incidentally, Scalia rhymes with Sharia, and it reminds me that the title of this talk of mine is "How do you solve a problem like Sharia?" Because I actually am going to tell you how I think we can solve this. But it's astonishing to me that we can quote Plato. It was Greek to me. We can quote Plato. We can quote Aristotle. We can quote John Lennon. We can probably quote Vladimir Lenin. And we certainly can quote the Venerable Montesquieu. That was Hamilton's phrase, the Venerable Montesquieu. Need I remind? He was French. This stuff is foreign. I don't understand why we can argue by analogy from Plato or by analogy from Montesquieu, but we can't say, you know, we've got a bunch of terrorism stuff. Let's look at some things Israel's done. Maybe they might help us. A couple of years ago, I gave the Brennan lecture here, and I picked, because I once heard Norman Dorsum give one of the most fabulous speeches I've ever heard about the judge he clerked for, Justice Harlan II. And my middle name is Harlan. My family liked Harlan, the first one, and that's where that got started in the Henry family. So I loved one of Justice Harlan's dissents, a dissent in a case called Poe versus Ullman. And this was a case where Connecticut had passed a law that you could not give even contraceptive advice to women. You couldn't even give, and contraceptives, of course, but I mean, this was a pure law. You couldn't even give contraceptive advice. And Justice Harlan, one of the paradigmatic conservatives with Felix Frankfurter of the Warren era, was totally offended by this. Here's this blue blood Rhodes Scholar guy who's probably not going to have a lot of trouble with this law. And he is just so offended, he talks for almost 60 minutes in the conference on it. And he writes this stinging dissent saying that we have traditions in this country, and those traditions are living, and that part of substantive due process protects this right. And the case was really about living traditions and substantive due process. That's what I wrote about. It was a constitutional interpretation thing, suggesting that the due process clause is flexible and has some room for evolution in it, which Justice Harlan believed. This was the case that Judge Bork, in his hearing, took Harlan to task for and attacked Harlan and said he was wrong. He needs to be an inerrant, a constitutional inerrantist, a textualist, and so forth. And I'm just reading this, writing my talk, and then I get to the last of the case, which I haven't read in a long time, and finally I see where Justice Harlan says, furthermore, the utter novelty of this enactment is informative. And he says, I've looked at all these jurisdictions, and not a single jurisdiction in the world prohibits this. And I'm writing my law review article, and I say, yep. That's a good Oklahoma word. Why you be, yep. There it is, foreign law. We had foreign law then. He looked at it to help us try to figure out the contours of substantive due process. So Oklahoma got this started, I'm sorry to say. And they passed this law. The people passed it, but the legislature started it. And it says, the courts, when exercising their judicial authority, I'm going to skip the stuff you don't need here, shall uphold and adhere to the law as provided in the United States Constitution, the Oklahoma Constitution, that's the hard part, the United States Code, federal regulations, established common law, the Oklahoma statutes promulgated pursuant thereto, and if necessary, the law of another state. The states are a little suspect too. Provided the law of the other state does not include Sharia law in making judicial decisions. The courts, now, then they even go further into what we call meddling. Specifically, the courts shall not consider international law or Sharia law. The provisions of this subsection shall apply to all cases before the respective courts, including but not limited to cases of first impression. So I guess that means they're going to be retroactively applied, which is kind of interesting. Well, the old Constitution here, Article 1, Section 8, Subsection 10, talks about that Congress shall have the power to, to define and punish piracies and felonies committed on the high seas and offenses against the law of nations. So our Constitution admits explicitly that the law of nations exists. Justinian was right. There are the Declaration of Independence was a legal brief written to the law of nations. We're independent. Here's why. We want the world community to acknowledge our independence. So Oklahoma passed this, and fortunately, the 10th Circuit, both Judge Miles LaGrange, who's the chief district judge in the Western District in Oklahoma City where I live, tossed the case out under the Lemon test, and and then the Court of Appeals, interesting panel, 2 Mormon judges and a very conservative Republican judge, unanimously tossed out the Save Our State initiative, referendum that was passed, based upon, it's kind of a technical opinion because this was a preliminary injunction, and so you have to go through all the folly-roll of did the plaintiff show likelihood of success, real and concrete injury that's likely to be redressed, and so forth. It can't just be a constitutional right, but there has to be a real concrete injury. And the court didn't seem to have any particular problem holding that. Well, Oklahoma has come back with another effort that's, I'm going to quit because there are other people who know more about this, but it's pretty discouraging and pretty confusing. And it seeks to say the same thing by just simply taking Sharia law out and applying this to foreign law. And interestingly, it excludes corporations. It applies this to individuals, but excludes corporations, which probably is a great relief to the corporations who would like to have their judgments collected and their contracts followed. So, well, what really can be done about this? Well, first of all, people need to speak out. And Abrahamic groups could start with the great law chapter of the Torah, Leviticus 19, Robert Alter's translation of 33 and 34. And should a sojourner sojourn with you, you shall not wrong him. Like the native among you shall be the sojourner who sojourns with you. And you shall love him like yourself, for you were sojourners in the land of Egypt. I am the Lord your God. So in the Torah, when you hear a commandment that ends with I am the Lord your God, that sort of means read it again. They don't all end that way. That means it's a big one. I really mean it. And that would be one thing we could do. Business groups have not adequately spoken out on this. I cannot understand it because its interference with foreign law would be so highly disruptive. Many, many years ago, well, it was actually 1987, which seems like many years ago, I made my first trip to the People's Republic of China, and all the American companies there were using Swedish choice of law clauses. That's because that's what the Chinese demanded. They didn't want American law. And the American companies were doing quite well with those Swedish choice of law clauses. I mean, we would totally wreck and mess up international commerce if we do that. Other religious groups should speak out. I was sharing with my colleague the Methodist Book of Discipline is just fantastic on this. It calls for dialogue with Muslims. It worries explicitly about prejudice against Muslims and Arabs in the United States. Listen to this passage. Even though Jews, Christians, and Muslims share the same covenant, in many of our cities, now that's pretty big stuff right there, share the same covenant. In many of our cities and towns, we continue to live as strangers apart. A positive foundation from which to connect with persons in other faith communities is recognition of some of the gifts they bring to a human community. For instance, through Judaism, Christians can connect to the covenantal faithfulness of God. Islam illustrates the joy of life lived in obedience to God's will. The spiritualities of indigenous peoples encourage a deep reverence for God's natural creation. Buddhism offers contemplative ways to connect to the divine. Hinduism, in its varieties, brings the gift of tolerance. Engaging in dialogue with positive expectation offers the possibility of sharing mutually beneficial spiritual gifts as well as overcoming past hostilities. It's pretty good stuff. Scholars and educators need to speak out. I was on a panel with Eugene Bullock, and at the end of the panel, where he and I disagreed about a few things, he came over and said, "Now, Judge Henry, you know that I'm very conservative." And I said, "Yes, I do. But I also know you're smart because our mutual friend Sandra Day O'Connor told me so, and you clerked for her." And he said, "Well, do these Oklahoma legislators, do they understand what they're doing?" And I said, "Well, no, except that they understand they're trying to poke Muslims in the eye. That's the whole point of this, is to do that. They don't really understand anything about the commerce and the settled expectations of law that they would mess." And Bullock said, "Well, I will come. I will talk in Oklahoma." And I said, "You're on. I have a lecture series at the University of Oklahoma." And he came and gave a brilliant talk. It will be published in the Law Review, and I'll make sure that you get it because it's very, very well done. And he begins by talking about an Oklahoman who is in the military. He goes to Germany. He lives there. He marries a German woman, has a child, and later they have a divorce. What are we going to do? We got to have some law to apply. And it's in all likelihood, given the fact scenario, which I'm not fully explaining, that he explained, it will be German law. And Merkel just won again. So we established a chair in Islamic studies at Oklahoma City University. And the Islamic community came out. I lost one trustee over this. I'm glad to see her go. The amicus briefs filed, there was a wonderful amicus brief filed by the American Jewish Committee, the Americans United for Separation of Church and State, the Anti-Defamation League, the Baptist Joint Committee for Religious Liberty. That's not the Southern Baptists, that's another group. And the Union for Reform Judaism, in support of the Muslim playing field. And some years ago, so other religious groups need to be involved, and we need to litigate. We need to file amici briefs. And a few years ago, it was Oklahoma's centennial, and the Muslim community was visiting the capital, and one of the women from Iran, Marjan Sarafipour, was talking to a Christian legislator and said, "What could we do to participate in this centennial?" And the Christian legislator said, "Well, the Southern Baptists came and gave everybody a Bible. Why don't you come and give a Quran?" Which she did, and all hell broke loose. And people were calling press conferences, "I won't take this," blah, blah, blah. And at another press conference, the leader of the Jewish community in Oklahoma City asked for a copy of the Centennial Quran and asked to have some time on the dais. Nobody knew what he was going to say. He got up and he said, "Today, I am a Muslim." This is a gesture of kindness. This is a good book. This is a book of wisdom. Today, I'm a Muslim. So people need to speak out. And the last thing, I was just thinking, isn't it interesting? We used to talk about the Supreme Court, and we used to say there's going to be a Catholic seat, and there's going to be a Jewish seat. And we went on and on about that. Well, now there's 6 Catholics and 3 Jews. So there are no Protestants there. I hope these guys don't figure that out. Because there will soon be a new constitutional amendment to require Protestants on the Supreme Court, if they can find them that will go along with it. So it is, I've tried to inject a little humor because that's how you live in Oklahoma. But it's very serious. And I think I've read some of the things that the Brennan Center has put out, and I really think that it's what I've read from the Brennan Center is correct, that this really down deep is simply an attempt to hurt the Muslim community in this country. And we know too much about religious freedom to allow that. Many of us came here. The Catholics came to Maryland. And in Oklahoma, you pretty much had to be kicked out of someplace else to come there. The Indians were forced there, and then the people that made the land run weren't the economic winners of society. They were people that were the down and out. And so we've really learned too much from our Enlightenment framers, and we need to stick with it, I think. Thank you.
Thank you so much. That was great. I think everyone really enjoyed hearing your stories about Oklahoma as much as your views on these bans. So we're going to move now into our panel discussion. And the first to speak is going to be my colleague Amos. And he, along with myself and another colleague from the Center for American Progress, actually wrote the report that we put out on Friday, which you might have picked up on your way in. Amos is now a Katz Fellow here at the Brennan Center, and he comes to us from the National University of Singapore and the NYU School of Law. So, Amos?
Thank you very much for being here. This is a very, I think this is a very important, if kind of underground movement to push for, and it's kind of a underground movement against Muslims, masked as a movement against foreign and international law, and it is something that we hope will generate a lot of interest and concern in the future. And I think one of the things that Judge Henry said that I would like to elaborate upon is this whole idea of, foreign law bans being couched as bans against foreign and international law, but are fundamentally motivated by the crusade against the Islamic faith. And ultimately, how this came about really was because the Oklahoma Court of Appeals outlawed the Sharia bans and basically said it's unconstitutional for you to explicitly target a particular religion. So all these anti-Sharia activists basically decided that they had to come up with a second iteration of the ban, and these are the foreign law bans we see today. And so just not long ago, I think they are still being justified on the basis of being, they are still being justified on the basis that we need to protect the Sharia. From the great state of Florida, a state senator called Ellen Hayes basically called Sharia a dreadful disease, quote unquote, and something that should be vaccinated against. And the vaccination was foreign law ban, and I think David Barkey from the ADL will talk about that a bit more. But one of the interesting questions at the start of the report writing process, at the start of research, was I asked Faiza, what does this have to do with national security? How are foreign law bans, what national security consequences or implications do they have? And when we're discussing about this and what the national security perspective on this is, I began to do a little bit of digging on some of the people that have advocated for these bans. Are in many ways the leading architects of these bans. We know from the New York Times expose that David Yerushalmi, a Brooklyn-based attorney, was the one who really drafted this ban and has pushed it out in 34 states, 7 of which have passed foreign law bans. But there's also another key figure in this movement, and I think he really, the story behind him, and his name is Frank Gaffney, his story really illustrates how foreign law bans are really linked to this movement that has a lot of adverse national security consequences if the anti-Muslim movement is allowed to progress even further than they already have. So let me tell you the story about Frank Gaffney. So Frank Gaffney is the president of a group known as the Center for Security Policy, and they have been one of the leading advocates of anti-Sharia and anti-Muslim sentiment, and they basically house, David Yerushalmi is general counsel to this group. But this group also was hired by the Department of Justice in 2010 to educate local, state, and federal cops about how to deal with the Muslim community. And so this was part of a larger scandal in 2011 when a series of news reports basically revealed that the FBI and local law enforcement agencies had been hiring anti-Muslim activists like Gaffney to teach terrorism readiness and prevention courses. And so there were 4 or 5 prongs of these anti-terror courses. One was many Muslim Americans have terrorist ties. Second, major Muslim civil liberties organizations such as the Council on American and Islamic Relations are actually a front for the Muslim Brotherhood. Third, Muslims are planning to wage violent jihad on all Americans. And one of the interesting things that came out of all these news is that Muslims seek to replace the US Constitution with Islamic and Sharia law. So you see how foreign law bans quickly, are actually part of this movement to inculcate even our law enforcement and intelligence communities that these are people you are to be afraid of. These are people that you are supposed to kind of spy on, for example. And one last tidbit about Frank Gaffney before I move on is that he sits, and this has implications in New York, is that he sits on the advisory board of the Clarion Project, an organization that has advocated for foreign law bans, and they were the ones that also paid for the production of the film called The Third Jihad, which was shown to more than 1,000 NYPD officers as part of their counterterrorism training. The film basically posits that Muslims are at war with America. So given that the people who are behind the anti-Sharia movement and the anti-foreign law movement in great part are the principal generators of fear and mistrust about Muslims, and the fact that they have also, to use their favorite phrase, infiltrated the upper reaches of the national security industry, I think it's not surprising why we have seen all these explosive reports and revelations about the NYPD and the FBI engaging in invasive religious profiling when conducting surveillance and counterterrorism operations. So advocating against foreign law bans, which is what all of us on this panel believe in, I'm sure a lot of you do as well, is also advocating against fundamentally flawed biases that inform our national security policies till this day, and so I think that kind of ties in why foreign law bans are so important, such an important tool for a lot of anti-Muslim supporters, and how they have fundamentally changed our national security landscape.
Thank you. Now, one thing that Amos didn't mention about the Yerushalmi Gaffney crowd was that they first went to the feds with this. So they went to the feds and they said, Sharia is about to take over the country. You guys should really do something about this. And they got no reception. So they did what all sort of legal policy strategists do. If you can't win at the federal government, you go to the states, and that's where they found a much more receptive audience. So we're going to move on now to our next speaker, Abed Awad. Abed is in private practice, and he is a renowned expert in Islamic law and in Sharia law. He also teaches at both Rutgers Law School and Pace Law School. And what Abed brings to this is really years of practical experience in sort of participating in cases where issues of Sharia law come up. So how does a practitioner actually have to bring these kinds of principles into regular contract disputes or family law cases? And so he brings a particularly important perspective for us.
Thank you. I like to walk. I have ADD. Can't sit still. I gotta keep shaking. Thank you very much, Faiza, for that very kind introduction, and with Amos for putting this panel together, and for my distinguished panelists, especially Judge Henry. I have a connection to Oklahoma. My sister got married and moved to Oklahoma a year and a half ago, so I visit Oklahoma regularly. So I'm going to place the practical aspect of how all this works. We all know, as lawyers, that the foreign law ban violates the separation of powers, the free exercise, the issues regarding freedom to contract, and the supremacy clause. But as a lawyer, as a practicing lawyer, one issue that's very, very important to me is the issue of the separation of powers. This ban basically, essentially what it's doing is divesting judges from their authority to determine what law governs based on 100 years of conflict of law jurisprudence. So we're taking that authority away from the judge. More importantly, for a practicing attorney, they're also taking away the authority of a judge to make findings, factual findings. In other words, without allowing him to look at the surrounding circumstances of certain cases to better understand them, we're also taking away the judge's authority in making findings of fact. And I'm going to explain some examples of how all this functions. As a lawyer, my ability to weave a narrative and present a story to a judge to better understand what are the circumstances surrounding this dispute so that he understands that story and adjudicates it based on this full picture. I'm not able to do that with such a ban. Let's talk about some examples. Sharia comes into play, or Islamic law comes into play in two basic categories. It comes into play as a foreign law. So some examples about foreign law, and I'm going to give you exactly cases that I actually worked on, either as an expert or as a consultant. Over the past 10 years, I've testified maybe 40 times in different courts around the country and prepared more than 100 reports relating to a component of Sharia law or the laws of the Middle East in litigation. So in a tort case, have a case where there's a wrongful death that takes place in a Muslim country. The plaintiffs initiate their case in a federal court in the United States. Well, as we know, based on the conflicts of law, the law that would govern would be the law where the tort took place. So here's an implication where now, with the foreign law ban, what do we do with this particular situation? In another case, a contract is negotiated and signed in Saudi Arabia. When you litigate your case in a federal district in New Jersey, the court is obligated to apply the law where the contract was signed. Another example, an example about validity of a marriage. The majority of jurisdictions around our country provide that the place where the marriage takes place is the law that governs a validity dispute as it pertains to marriage. So now what do we do with marriages that take place in Muslim countries with a foreign ban that a judge cannot even entertain whether this law applies and the marriage is valid? Other examples relating to, let's say, a ceremonial marriage. Ceremonial marriages without a marriage license under New York law is considered a valid marriage. So the judge needs to take testimony on whether this marriage was consistent with Islamic law in order to be able to determine, is this ceremonial marriage sufficient under New York law? So this is one area where Islamic law comes into play as a foreign law, whether it's by choice, by conflict of law, or the place where the tort has taken place. The other way that Islamic law comes into play in a litigation is what we would call extrinsic evidence or parole evidence. And here what I mean, it's evidence that aids the court to better understand the expectations of the party to a dispute, to clarify an ambiguity, to uncover a fraud, to basically determine custom or usage. The extrinsic evidence here is an aid to the court. Example, you have a couple that get married in New Jersey and they enter into a Muslim marriage contract. Dispute arises, they go in front of the court, and the wife seeks to enforce her marriage contract. Now the judge is looking at this document, has no clue. He's not knowledgeable in Islam or Islamic law. And he says to himself, I have no idea what we're talking about. I want expert testimony to explain to me, what is a Muslim marriage? Offer acceptance of marriage. There's a concept, there's a provision called a dower. What does that really mean? And after the judge looks at the surrounding circumstances and hears this testimony about Islamic law and Islamic culture, now the judge has a better understanding of the big picture. He goes and he applies state law. He doesn't apply Islamic law. He looks at these surrounding circumstances. Do they comply with all the requirements of contract law under New Jersey law? Was there offer? Was there acceptance? Are there any valid defenses? Was there fraud, misrepresentation, undue influence, coercion? You look at these circumstances. So in the first set, what we talked about as it pertains to foreign law, it's not that foreign law supplanting New Jersey or American law. It's American law dictates that foreign law applies. When you present your case in front of a court, I do many of these cases where there's conflict of law issues, where we're briefing the federal court, here's the law on conflicts in Texas. And based on that, it's really the law of Qatar that really governs, judge, and you need to make that determination. So it's American law that dictates the applicability of the foreign law. It's not the foreign law coming to supplant or replace the Constitution. Also in the extrinsic evidence aspect of it. You have situations where an estate plan, for example, that provides, in the event of my death, my estate should devolve according to Islamic law. It doesn't have much details other than Islamic law. Well, here the judge needs to entertain or hear testimony on how does Islamic law distribute an estate in order for the judge to effectuate the intent of the testator. So as you can see, Islamic law is very diverse and applies and is relevant regardless of religiosity, or it's more relevant to more religious Muslims, but even non-religious Muslims who, like the majority of us, may marry religiously. Most of my colleagues who happen to be Christian or Jewish or what have you don't go to church or don't go to synagogue, yet they get married, they have a rabbi appear and solemnize their marriage, or go to a priest, or a Muslim who doesn't, you haven't seen him in a mosque in 10 years, brings an imam who solemnizes his marriage, or provides a contract for his marriage. So these marriages are entered under Islamic law and under religious law. And if we do not allow courts to consider this, we are doing a disservice in divesting that court of its authority to determine the applicable law, and more importantly, on determining the findings, the factual findings necessary. So in this particular context, as you can see, one thing that's very important, everything I talked about is always subject to public policy. I've been on cases where, on the other side, where I'm testifying because actually the provision that is applicable is contrary to our public policy and should not be recognized by a state court. But in other circumstances, it doesn't violate our public policy and should be recognized. In one particular case, it was a recognition of a Syrian divorce decree. In that particular decree, the court changed custody because the wife remarried. So the court in Tennessee that was considering this said, you know what, I'm not going to recognize it because it would be contrary to Tennessee public policy that an automatic transfer of custody because of remarriage would not be consistent with our public policy. So in other words, even if foreign law applies, doesn't mean that it will control. It all is dealt with within the strictures of our Constitution and our public policy arguments. In a recent case, again, we're divesting the judge from his authority. We're considering judges to be stupid, and we're considering judges that they need direction. A judge in New York recently enforced a $250,000 judgment out of an Abu Dhabi court. And in that $250,000 judgment, it was for a wife for her dower. She negotiated in her marriage contract, at the time of divorce, you're going to pay me $250,000. He divorces, they were in a Muslim country, she enforced it. The husband provided every conceivable argument that Islam and Islamic law violates the public policy of the state of New York. And the judge said, you know what? Some of what you say is correct. It would violate the public policy of New York. But none of those issues are implicated in the enforcement of this particular limited issue about the $250,000 dower that you agreed to. So judges have the tools to look at the issues before them and to determine, can they enforce a contract without violating public policy. A case that I handled in 2002, Odatola versus Odatola, was a case before a trial judge in New Jersey on the enforcement of a marriage contract. What the judge did, in the end, was said that I'm going to apply neutral principles of law as long as the enforcement of this Muslim marriage contract in directing the father, the husband, to pay the lump sum that he agreed to does not violate New Jersey public policy. I see no reason why not to enforce it. So the judge did his public policy analysis and evaluation, and as long as it passed the public policy test, you have no problem. For example, in France, our punitive damage awards are against their public policy. So they would not recognize a punitive damage award emanating out of a United States court. So we need to keep in mind that the legal subtleties and the nuances are what's missing in this debate. You don't need a foreign law ban to tell you that if an agreement says that you're going to have a polygamous marriage, our judge is not going to recognize a polygamous marriage because it violates our public policy. You can't have a contract that's going to say that you're entitled to lash somebody 50 lashes because he stole something in New Jersey, or anything relating to issues regarding adultery and what have you. These are issues that are not implicated in any of the litigation that takes place around in this country. So in the end, in a nutshell, what you see is that the impetus behind this anti-Sharia movement is nothing but bigotry and discrimination. And this is not a surprise. Most of the proponents have admitted on the record that the target of these are Muslims. The target is Sharia. And what makes this more insidious and more dangerous is that many of them, including Shalami, was quoted in the New York Times saying that he didn't care if they passed, the legislation passed. All he wanted to do is create enough friction, enough questions for people to say, what is Sharia? And then people to associate Sharia with something that's so horrendous, so horrific, that marginalizes Muslims and fuels the Islamophobia. That's really the true story behind the anti-Sharia movement. As lawyers, we know that there is no added protection in providing with this foreign law ban. It rather implicates and undermines the civil liberties and the freedoms that we cherish most in this country. Thank you.
Thank you, Abed. So, our next speaker is emblematic of something that you mentioned, Judge Henry, which is the sort of interfaith cooperation that has been taking place around pushing back against the foreign law bans, and that's David Barkey, who's the Religious Freedom Counsel for the Anti-Defamation League. And David has been very helpful to us as we were doing this research, but has also been one of the leading advocates against these bans at the state level. He's been particularly successful in Florida, where he was part of the movement that fought back against a ban on foreign laws earlier this year, right? It was for the past 3 years, right? It was successive years. And so he's going to bring a different perspective for us over here, which is he's going to talk about what it's like on the state legislative front lines as you try and push back against these bans. David.
I think I'll stand too. Good evening, everybody. Thank the Brennan Center for having me. I also want to compliment the Brennan Center on a very thorough and well-written report on this issue. So I'm very pleased that you did that. What I want to talk to you in my 5 to 6 minutes is practical strategies and issues that arise in opposing anti-Sharia measures in the state legislature. As was said, I've worked on this issue 3 years running in Florida, starting in 2011, and I've also worked directly and indirectly on other measures in 8 other states with some of my colleagues and also in other coalitions. Now, it's clear from this discussion whether these measures, whether they're overt, like the Oklahoma Save Our State amendment, which I know was passed by 70% of Oklahomans. You should have raised that. It's a wonderful state. Or if they're covert in the form of these application of foreign law bills. These are about anti-Muslim bigotry. We've called it camouflage bigotry. But I would submit to you that based on our own trial and error in opposing these things, that doing a frontal assault, opposing them just based on anti-Muslim bigotry or their extremist foundations, it don't work. Okay? I'm an ex-New Yorker. It does not work in the legislatures where it's getting traction, because remember, this is not happening in Massachusetts or New York or California. This is happening in very socially conservative legislatures, and guess what? They don't care if you say, this is anti-Muslim. So what? They don't care. I mean, you just have to understand that. You have to get out of the mindset here. They don't care. And the other thing, particularly with regard to the application of foreign law bills, which are neutral on their face, or purport to be, is it gives them plausible deniability. I've seen this on the floor of the Florida Senate and the Florida House. Well, this is, you'll have a more moderate legislature. This is about bigotry. No, it's not. This doesn't target anybody. It doesn't target any group. So you don't get much leverage there. So the question is, what works? What do you need to focus on? Well, first of all, obviously what's critical is, what's our message going to be? What's the opposition's message going to be? And also what's also important is, who's going to give the message? And what I would also say to you, although we don't want broader bills in place, broader bills are easier to defeat in the state legislature because it gives more quote-unquote unintended consequences that we can oppose the bills on. So what I thought I would do is talk a little bit about Florida. It's where I have the most experience that can flesh out some of these practical issues. So back in 2011, Senator Hayes from Umatilla, Florida, a former dentist, filed the application of foreign law bill in the Florida Senate, and there was a House bill filed as well. It was a broad bill. It applied to all Florida law, and what was important that year, it had no ecclesiastical exception, no religious exception. So the Catholic Conference, the Catholic Church, and the Southern Baptists were really worried that this bill could interfere with their internal governance, and that's what killed the bill. What happened was, I learned this from the Catholic Conference, I mean, Hayes doesn't talk to me, is that the Southern Baptist lobbyists had a discussion, said we're really worried about this after it had passed one committee, and basically Hayes decided, I'm going to kill the bill for the session, rolled over the bill. So it's kind of like the start of a bad joke when the Catholics, the Southern Baptists, and the Jews all believe something bad. So what we started to oppose it on was its detrimental impact on the observant Jewish community and their use of rabbinical tribunals, and I'll talk about that in a minute. So 2012 comes around, Senator Hayes wised up a little bit. He narrows the bill. Now it's only limited to domestic relations law, so divorce, custody, etc. And it contained an ecclesiastical exception. So basically the Catholics and the Southern Baptists, they stay out of it. They had no dog in that fight. They decided they weren't going to actively oppose it. I mean, before I get into how we oppose it, I just want you to know whether or not this affects the Jewish community, ADL would oppose this because it's just wrong. But the arguments that we're making are using the leverage that we have in a particular state legislature. And what we argued was this has a detrimental impact against observant Jews. And why are we using that argument? Because in conservative legislatures, they tend to be a little more sympathetic to Jews as a religious minority than others. It's just a state of fact. It's not good, bad. It's just a fact. So basically, this bill applied to religious tribunals, including Jewish religious tribunals called Bet Dins. And observant Jews use those Bet Dins to arbitrate marital dissolutions, and those arbitrations often are used for the basis of a civil divorce. So basically, the argument was, you pass this bill, observant Jews in Florida can't use the Bet Din to arbitrate their marriage and use it for the basis of civil divorce, and any out-of-state divorce premised on a Bet Din, from New York, California, what have you, is not going to be recognized in the state, as well as any kind of agreement emanating from it, such as property dissolution. Long story short, still passed the House, passed the committees in the Senate. The bill never got a full vote in the Senate. Now, is it because of what we were doing? I don't know. There was a lot of contentious legislation that year. The clock ran out. We only have a 60-day session, so it's really quick. Okay, 2013 comes around. We've had 2 years of experience. We've got a nice coalition bill. We're running on all 12 cylinders. The 2012 bill, which had been filed the year before, gets reintroduced by Senator Hayes. About a third through the session, they decide they're going to exempt out religious tribunals. And so really they're trying to focus more on just laws of foreign nations. So on the one hand, well, that helps in our argument, and maybe it's because of those arguments we were making, but on the other hand is, well, what's the winning argument to oppose this? Because we want to find a leverage point. So I had to gain a little expertise on Israeli divorce law. And so our new argument was, well, you did the Bet Din thing here, but you may not realize this. In Israel, all divorces of Jews are done by rabbinical tribunals, and the state of Israel puts their stamp on it. Basically, you're divorced. So, same issue. Under this law, anybody who gets divorced in Israel, whether they're an American, an Israeli, or another citizen, you're not going to recognize their divorce and anything emanating from that because, I forgot to explain this. Sorry, I should have explained this. Under Jewish law, we have the get law, which says that only a man can give a divorce to a woman. Violates equal protection, right? It's not going to fly under your anti-Sharia, under your application of foreign law bill. We also had some really good help from the Florida Bar Family Law and International Law sections. Basically, the International Law section said, hey, this is really bad for business. Florida, especially South Florida, is a center of business in this country with South America and Central America. And this might say that an Argentinian prenuptial agreement or divorce is no good here. Maybe not so good for business. And the family law section basically argued that you're going to add a lot of costly litigation expenses. That's a big argument in the Florida legislature. They always want to cut taxes and they want to cut litigation expenses because in any case involving a foreign law, you're going to have to get experts. There's going to be a battle of experts. Does this apply? Does this comply or not comply with the law? And you're going to have hearings on it. What's also important is who spoke out against the bill. We had a Muslim partner in this, a group called Emerge, and we all kind of got together and said, we really don't want to make this about Islam. We want them to find another reason to kill the bill. So basically she, in a friendly way, said to the Muslim community, you know what, don't testify at this hearing. It may backfire on us. And the strategy, it worked. The Senate Rules Chair, who's the second most powerful person in the Senate, we know he held up the bill from going to the Senate floor because of the impact on the Jewish community. And the reason I know this, and this is Florida politics, okay? Senator Thrasher told a Jewish senator, because he's Jewish and he knows everything about Jewish law, right? You go explain to Senator Hayes why this is bad for the Jewish community, and I got a call saying you got to write the bullet points so that this senator can explain it because he didn't know what he was talking about. So the bill ended up dying on a procedural vote that I don't need to go into. I have no doubt that this bill is going to be filed again, and I think we're going to use the same strategy. Basically, don't focus on the anti-Muslim issue when it comes to the legislature. Focus on impacts on the business community and other groups, and really think hard about who speaks out, because that's just as important. Thank you.
Well, at least they're keeping you in a job, right? So, thank you, David. That was really interesting to hear how you did that. And that's actually, when we started working on this issue, is also something that we came up against, which is that we wanted to explore what these laws meant, not just in a symbolic way for the Muslim community, but also what kind of impact they would have in real terms. I'm going to do a couple of questions with moderator's privilege, and then I'll open it up to all of you. So one of the arguments that proponents of foreign law bans use is there's no harm here, that this is no different from the law that our courts already follow. So what's the harm? What's the harm in a foreign law ban that says, well, you can't enforce a law that's not constitutional?
You want me to take that question?
Anyone can
I
take
mean,
it.
the thing is, look, you got to understand that if you think, I'm going to have a little catharsis here about state politics. If you think Washington is bad, state legislatures, it's even worse. First of all, most of these folks are part-time legislators. Most of them aren't attorneys. They don't understand these issues. They simply don't. So to them, they're sort of American law, what's wrong with that? And they don't understand the constitutional issues. I mean, as far as I'm concerned, every member of the state legislature should get Common Law 101 because they don't get it. I mean, and on a lot of issues, I'll just so you have a sense. Florida was also the state that decided to do drug testing of every welfare recipient. And a senator gets on the floor, it's like, well, I don't understand why, what's the big deal? We do this all the time with private employees, we drug test them. It's like, well, there's something called the Fourth Amendment. But so it flies over the head. So they don't get the legal nuance. But the other thing is, even if they did, I think there's some of them, they just don't care. They just don't care that where this is coming from. They don't care that it's based in bigotry. I mean, I'm not saying all of them, but I'm saying that the majority just don't care. And then there's also something else, which, and it's probably all politics, legislators, they don't necessarily vote their conscience. The dirty little secret is in Tallahassee. Tallahassee is run by about 6 people. And usually the majority party is given their marching orders. This is how you're going to vote. And if you don't vote the way you want to vote on this, you're going to lose your chairmanship, you're going to be out of disfavor, you're not going to get campaign funding. That's the way politics works. So that's why I say you got to find the leverage points that work in killing these bills. And unfortunately, in the more conservative states, the reason why we oppose this isn't necessarily, in conscience, is not the reason why you're going to get them to get a no vote or to even slow it down.
Did you want to say something?
I wanted to add something to that. There's an old saying in the Oklahoma legislature that if it ain't broke, don't fix it. And that's really, Hippocrates, first do no harm. And the other thing is, I once had a brilliant Nobel laureate, Mary Blumberg, tell me, he was asked a question, when would we have a pill that would cure baldness? And Dr. Blumberg, who was bald, said, first of all, what's wrong with baldness? But then he said, the answer to the question is never. There will never be a pill that cures baldness, because we've learned one thing in medicine, and that is that nothing does one thing. You may have a pill that cures baldness, and your left arm will fall off. And so, you know, we have 800 years of common law or more. 1066 is the Norman Conquest. And we've got, you know, this country's planted thick with laws, Thomas More says in Man for All Seasons. So you mess with one, you create a bunch of other problems. There's a lot of unforeseen difficulties here. The chairman of the Oklahoma Senate Judiciary Committee has taken this one step further, David. He refuses to hear any acts written by the Uniform Law Commission of the United States, the people that brought us the Uniform Commercial Code, which secures all the property of all of you people here in the room, your cars and your things that you borrow. He will not hear any things drafted by the Uniform Law Commission because it didn't come from Oklahoma, the seat of all wisdom. You know? So I do agree. I think it's important to develop allies. I think it's important. Sometimes you have to ask people to take a backseat role. I think litigation still works. I think amicus briefs are helpful. I forgot, because I messed up my computer and I had to go back to the old legal pad to write this. I forgot my last solution, which is pretty radical, and so I didn't want to be sure to say it. Nikki Edwards, a former Oklahoma congressman who is now with the Aspen Institute and was at the Kennedy Center, has come out with doing away with the closed primary. He thinks we should have an open primary. And I am ready to consider that, because the problem in Oklahoma, David, is that Oklahoma is a red state to begin with, and the people that vote in the primary are the people that are crazy. And, Democrats and independents don't have a vote. And so my Republican colleagues, my Republican friends in the legislature, the moderates, are terrified to do anything that wouldn't just appeal to that least common denominator. It's public choice theory. You know, every legislator, there are only two kinds of legislators, according to public choice theory: maximizers and maintainers. Most legislators are maximizers. Everything they do to what? To get reelected. There are a few who are maintainers, who will push the envelope on something that's really important to them. And public choice theory says that's all. The rest are statistically insignificant. Now, there is a view that there are civic Republicans, and a few of those people will drive the bus over the hill to do something that they think is right. So I don't think these things are harmless. I think we shouldn't fix things that aren't broken, particularly when who knows whether your left arm's going to fall off.
They're basically such a massive and broad ban on foreign law would implicate so many things and violate our existing law, as the judge just explained. So because it implicates 100 years of conflict of law jurisprudence, freedom to contract, and so forth, we're going to have to start creating exception to exception to exception. And again, I go back to the same point. We're divesting the court from the ability to see all of the circumstances of the case and make its decision. We're saying we need to replace the judgment of the court's ability to deliberate and consider everything, and replace it with a simple phrase, all foreign law is banned. I mean, that just goes contrary to anything about our adversarial system and about the importance of a judge making that decision, seeing the demeanor of the parties, seeing all the evidence, seeing the full record, and from there make that decision, as opposed to a broad ban.
So maybe we need to organize some former judges around this issue.
There are not as many former judges out. Most judges stay.
All right. Well, I'm sure people have questions, so I want to give people a chance. Please, would you just identify yourself? Just tell us your name and.
Sure. My name is Dana Heights. I'm an attorney and recent Master's in International Affairs recipient. I actually have two questions. First, kind of a flip side to the one that you just posed. What, if any, legal arguments are used to support the ban on foreign law, apart from why not? And second, inspired by Abed's comments, but to anybody, does there even have to be a dispute at issue for foreign law to be a concern? For example, if you have a married couple filing joint state taxes, but they were married in a foreign country, would that become an issue at that point?
I think on the state law issue, absolutely, because if you were, again, let's say you're the Israeli couple that divorced, I mean, you know, there's, and we cite the numbers, there are a lot of Jews in Florida, a lot of Jews, I mean, that's, you know, where the Jews are. Not just where the boys are. But you have ex-Israelis living there, and if the state law says we're not gonna, well, I guess I have to look at the statute. The statute applies to, because it applies to any administrative ruling, any arbitration, any court ruling, any well, it used to be tribunal, not anymore. So I don't know if the filing in it itself, but if there's any kind of dispute where the administrative agency would have to make some kind of rendering, some kind of decision, let's say in your property taxes.
Well, think about it this way, right? If you file taxes jointly as a married couple, you save money as opposed to if you file them
Absolutely. No,
individually.
I realize that,
yeah,
but my point is because what the question is what would trigger the law? Would the filing in and of itself trigger the law?
The acceptance of the return.
And I think because the Florida bill, and I'm not talking about other bills might be different, like the Kansas bill is much broader. The Florida bill is triggered when any one of those entities renders a decision. So basically, if there was some kind of dispute relating to the tax filing, and then all of a sudden they say, well, you're not even married, then I could see that happening. So absolutely, and it wouldn't have to be just from a court, it could be an administrative agency.
Here's some examples. Every example I'm giving you is the actual case I worked on. Two parties married in Egypt, lived in New York most of their life, decided they had no children, no property. They went to the Egyptian embassy and obtained a dissolution of marriage. Under Egyptian law, that is a valid bilateral divorce. They separate, the woman wants to remarry. Now she has an issue of when she goes to the immigration and submits this divorce, is this going to be recognized? So there's no dispute here. It's just a matter of, is this divorce valid? And under international law, there is some theory that if the embassy's territory is technically part of the nation's territory and it could be extended, and that would be a divorce as if it was issued in Egypt. Another example, you go in front of a judge and you're probating your will, and the will says Islamic law. Everybody's not disputing, but now how is a judge going to do that? Another example would be, I had this very interesting case where it was a divorce out of Palestine, out of the Palestinian territories. The American immigration refused to recognize it, so the guy was going to be deported. But under Palestinian law, that divorce was valid. So the issue was the validity of that divorce. So it doesn't always have to come up, like you said, in actual disputes. Your wrongful death, I had a case, I could say that what would happen, but then you would know it was an air crash. But I won't tell you which airline. What happened was, we needed to file a wrongful death. Who's the surviving parent? Who's the surviving spouse? So we had to look for her marriage certificates from like 40 years to try to present to the court to get the letters of administration that she is the surviving spouse and has the legal ability to represent the estate. So here you see how many of these examples have nothing to do with litigation or fighting, but rather to preserve a wife to be a surviving spouse, to dissolve her the intention, the testator in the will, the validity of a marriage or a divorce, for God's sake. All of these are very personal and private issues that this ban would totally decimate.
And so to answer the first part of your question, which is what legal arguments are used to support these bans, the answer actually is it's very convoluted legal reasoning, because all these bans really rest on rhetoric rather than reason, and so they kind of make it up as they go along. So it's backward reasoning. So they start with a very broad ban, anti-Sharia ban, and then they find out, oh, it's unconstitutional. Then they say, okay, let's replace it with foreign international law. Then all kinds of problems, supremacy clause, constitutional problems, as well as, choice of law problems start coming in. They say, okay, let's insert this phrase. We will ban foreign law that comes from any legal system that is inconsistent with, you know, the U.S. Constitution and our state constitutions. Now that sounds right at first, because of course we would want to ban foreign law that is, you know, would be considered unconstitutional and against public policy. But when you state that, you know, we are going to ban any the foreign law that comes from any system, basically any country, you know, that contains any kind of laws, whether related to the case at hand or the dispute at hand or not, that is inconsistent with our constitutional rights here, then there are a lot of problems with that.
Well, that's a lot of countries.
Yes, I know. So
That's
I
most
think
of the world.
Faiza mentioned something about the right to a jury trial just now. A lot of countries don't have the right to a jury trial. Does that mean that in a civil case, you know, a contracts case that comes before a state court, the fact that an award wasn't basically wasn't decided on the basis that there was a jury trial. After a jury trial means that that award has to be completely invalidated. So the legal argumentation just falls apart even as they try to reel back, you know, these bans and try to justify it.
I mean, one thing that's kind of interesting about the strategy that the people who promote these bans have is they say Sharia law is a big problem and foreign law is a big problem and we've got to do something about it. And at the same time they say, but this law that we're putting in place doesn't really change anything. So it's kind of a two-track thing where they
Well,
sell.
that's how they try to sell it also.
Right, exactly,
In their
yeah.
committee. And the other thing that comes up, which is, it blows me away, in Florida, there is not one case on the books that the proponents can point to say, we need this. Not one case. And so you'll have a colloquy on the
Well,
floor.
they're the same in
You'll have a
Oklahoma, right?
colloquy on the
They mentioned
floor
that.
where one legislator says, like, well, can you point, you know, Senator Hayes, can you point to one case where that would suggest the need for this? I can't, but we don't, it's preventative. I mean, that's, you know, so it's the solution in search of a problem, but it really is, it's not legal, it's rhetorical, and it's a very simpleton view. You know, American law should be applied in American courts. But the thing is, I've had conversations with fairly sophisticated businessmen, non-lawyers, trying to explain, why is ADL taking this position? Why are you taking this position? And the guy didn't even realize that. I said, I wanted to use a non-Jewish example. I wanted to use Argentina. I said, well, in Argentina, they don't necessarily have the same due process rights that we have here. So an Argentinian executive coming here who got divorced in Argentina 20 years ago and can't find his ex-spouse, moves to Florida, finds the love of his life, wants to get remarried, guess what? His divorce is no good. And he's like, well, they don't recognize their divorce anyway. I'm like, yeah, they do. And so, but this is a person who's, you know, a very successful businessman, you know, obviously savvy, and you know, doesn't understand that because he's not a trained attorney, but there's that appeal there. But I haven't heard any real legal arguments. I mean, actual, you know, reasoned legal arguments. It's either American laws, you know, American courts, this doesn't do anything, it's the status quo, and that's how they get it through committee, and they've got to go through a lot of stuff, but I haven't seen any reasoned legal arguments.
Well,
There is no
there's
reason.
one that is on its face, has some credence, and it's interesting because you question the good faith of some of these groups, but they talk about the New Jersey
Yeah.
case
Right,
where
New Jersey.
the wife, she's married under Muslim marriage, and her husband forcibly has sex with her and claims that under his version of Sharia law, and remember, you're gonna have to go to the country where it was because it's gonna be different. I don't think you get anywhere in Morocco with that argument. There's too many French around, you know. But I mean, it was a good thing. So the one court determined that the husband did not have the proper mens rea, but was immediately reversed on appeal.
Exactly.
And so, you know, the issue of greatest conflict in a lot of relations with Arabic countries are women's rights. It's hard for the West and I've said this in many countries when I've represented our country, that we got to have dialogue about this. Now, there are women who like various provisions of Sharia, and so it's the protective provisions I'm talking about. There's some women that like the veil and think it is protective of them and so forth. So it's a complicated thing, and this water is moving, this Sharia is moving, and so the danger, as Abed pointed out, that there's no danger for this because of American public policy. And so all of these things that are harmful to women are going to be contrary to American.
Let me make a point on the New Jersey case. The husband alleged that he is entitled to have sexual relations upon demand. Under our law in New Jersey, in New York, if a wife refuses to have sexual relations with you for an extended period of time, that's grounds for divorce. Under Islamic law, it is the same. If your wife refuses to engage in sexual relations, your contract of marriage is a contract for you to have legitimate, lawful sexual relations with an individual that is not fornication. Your remedy is not to force her to have sex. Your remedy is a divorce. That's under the classical law. So this individual alleged that he had a genuine belief that he engaged with sexual relations upon demand was his genuine religious belief. The judge, reading the sexual assault statute in New Jersey, read that it requires a mens rea, requires a purposeful intent to commit the crime. So he said, I did not see that intent. Therefore, I'm not going to enter a final restraining order. A criminal case was simultaneously going on, so that case was going to continue. In the end, the appellate court simply said, you don't need a mens rea. As long as there is a knowing engagement in sex against consent, that implicates a sexual assault. And it was reversed. And, by the way, his genuine belief is contrary to Islamic law, so it's not even the law of Islam.
Do we have a question in the back?
Yes. You talked about how to oppose the enactment of these laws and also what would happen. You've given many very, very interesting examples of how courts apply foreign law in multiple situations. Now, I'm just looking at the first page of your report where you say that aside from the Oklahoma, there are at least 4 other states that have enacted foreign law: Kansas, Louisiana, Tennessee, and Arizona. Could you tell us how many of these hypothetical situations that you talked about that arise in states that don't have foreign, how many of them have arisen in these 4 states, and what's happened? Have there been a lot of examples where people tried to introduce the kind of...
Oh, yes.
And where the courts have rejected, and what has happened then? What kind of
Post the legislation.
Yes, post legislation. Recently, in a Kansas case, Kansas adopted the ban. You had an Iranian woman with a substantial marriage contract, and I think it was more like $150,000 dower. And she moved to enforce her contract, and the court would not consider it because of the Sharia ban. So we have a situation here where the ultimate objective of protecting women actually worked in reverse. And keep in mind, I'm litigating a very interesting case regarding the enforcement, whether a woman's rights are going to be better in Egypt as opposed to the United States. Islamic law, family law, is very beneficial and advantageous to women under certain circumstances. For example, because under Islamic law there's no concept of marital assets, the assets that you acquire during the marriage continue to be titled in the name of the person who acquires them. So if the wife is a physician and well-to-do executive and makes a lot of money, Islamic law actually protects all of her wealth from the claim of the husband. And I've had these cases on a regular basis. Recently, I've represented a female Muslim doctor making $700,000 a year with a deadbeat husband who's making $5,000 a year who says, I want permanent alimony. And she's saying, well, my religion, why am I going to pay this guy any alimony? I had another who's an attorney. Same thing, she's making about $1.40, husband making $10, and half the year he's in Morocco. She says, why am I have to pay him alimony? The judge says to me, Mr. Awad, you know, you understand our statute is gender neutral. There's an economic dependency here. I'm sorry, I have to order that this is an alimony case. So under Islamic family law, there are circumstances that are very protective of women. So same thing, we can't have a general foreign law ban because there are things that would fall under it. There are circumstances under Islamic law that are not equitable towards women and are not acceptable. But depending on the facts and depending on the circumstances, let the judge see those circumstances, understand the case, let him make the decision as opposed to a general ban.
Have there been any cases in these 4 states that have passed the foreign law ban?
Kansas passed the
No, no.
ban.
Just one, Soleimani versus
No, I was just going to ask whether you know of any cases where it has been applied to a non-Muslim situation, because that's the point that that you were making, that an effective tool is to show that whether it's Jewish religious law or other groups, has that actually happened? I know these are 4 conservative southern states essentially, but are you aware of any of that yet?
Not yet.
But I think the point is that even though there are no concrete cases where the bans have actually been applied toward contractual relations, the point is that it creates that tremendous uncertainty for people going forward.
Oh yeah, I'm aware of that. I was just curious whether in the short
They're
time that
pretty
they've
new,
been.
right? I mean, this is
Yeah.
something
Yeah.
that's really emerged in the
Very
last
new.
2 years. I think
2 or
the
3 years.
Awad case was 2011.
Yes.
So it's the last couple of years that these bans have been going through. And we're expecting to see more of them go through at least some of the state legislatures
Well,
this year,
you
right?
know, we're talking about the Bible Belt.
Right.
We're up to 7 states already at this point.
I think that one of the reasons you haven't seen more is, like in Oklahoma, the law was thankfully declared unconstitutional. I have been very surprised that the business community has not been more concerned about this. Because as I said, Oklahoma's largest company, Devon Energy, is 40% Canadian. And if that law had not been challenged and Oklahoma courts were to apply it, essentially Devon would not be able to bring any lawsuits in Oklahoma. So there's not going to be a horror story for you, except that it's going to be good for the Canadian lawyers.
SABIC versus ExxonMobil, 2005 Delaware case. The law that governed in a contractual dispute between ExxonMobil and SABIC, a Saudi company, was Saudi law. The judge determined, based on expert testimony, that under Islamic law there is a concept of what we would call enhanced damages, similar to what we would call speculative damages or consequential damages arising out of the direct breach. $500 million awarded to ExxonMobil based on an interpretation of Islamic Sharia law from Saudi Arabia. 2005, $500 million. So again, I second Judge Henry. Why is the business community not getting in and stopping this nonsense?
Isn't part of the reason that many of these laws now have a corporate exemption? So a lot of the business community thinks that it isn't going to apply to them,
Yeah,
right?
but
I mean, that's part of the reason, like what we were
Absolutely.
talking about earlier, that
And that's
David was
part
talking
of, that's part
about.
of the reason why, that was one of the first things they put in was a corporate exemption.
Right.
But based on the Citizens United, that's now an equal protection issue, because if a corporation is an individual, we're treating the corporation different than the other individual.
Well, and look,
I think let's give the audience a little some chance. Please go ahead and then.
I know these are state law bans, but there are situations, many of them, where federal law incorporates state law on issues of status, like the Social Security Act, for instance, on issues of entitlement to benefits, uses state law for determinations of marriage and parenthood, etc. Are there any situations where the federal government has realized that that may mean that in effect, if they defer to state law, that they will be enforcing this kind of ban as well?
I think you've thought ahead of all of us.
Yes, that's a very good
That's a great
question,
question.
yeah.
I think that's a very interesting question, and it's really, here's the lawyer answer, it depends. What triggers the bill? Because, for instance, my understanding of the Kansas law, the mere mention of Sharia law could trigger the law, versus the Florida bill is a little more narrow in that there has to be some actual application by one of the entities mentioned in the statutes to trigger it. So the question is, what's the triggering mechanism? But it certainly could be an issue.
I mean, I think the issue comes up really in arbitration, and there is this tension between federal law on arbitration and state law on arbitration, and there is the Federal Arbitration Act, which arbitration tribunals, whether they are at the state level or the federal level, are supposed to follow. So the foreign law ban comes in because the state says, well, we kind of, have this assumption that we control interpretations of state law, and how that's going to play out in arbitration tribunals and how this is going to be reconciled with the Federal Arbitration Act is something going forward that will be very interesting, very complicated certainly, and something we want to look out for.
There have been a couple of status issues that have arisen a lot. One is cousin-to-cousin marriage. Some states allow it. A lot of European countries and Middle Eastern countries allow it. Some states don't. And then, let's see, there was another one. Minors. Let's see, there was a Louisiana case, I think, where the parties were 15, each were 15. And so under the law where they were married, that was okay. And so it was not considered violative of state policy to have these two 15-year-olds married. They were married in Lebanon, I believe, and it was valid. Parents were there, blah, blah, blah.
In the back.
Given the panel's sort of general argument that these bills, their primary goal isn't to affect any change in substantive law that would be different from the status quo per se, but to incite sort of these negative perceptions about what Islamic law means and what it means to be a Muslim in the U.S., given sort of what that strategy in Florida was, right, which was to tell Muslim advocates and Muslim groups to sort of take a step back and allow other groups and advocates to represent sort of the battle against this bill. Wouldn't it be more desirable in the long term to have these advocates, these Muslim advocates, openly participating in the dialogue in Florida in particular, and to represent sort of Sharia law to the public rather than allowing sort of other interest groups to participate in the sort of exclusion of people who talk about Sharia law?
Well, I mean, a couple things. One is, do you want to stop the legislation? That's my first and foremost goal. The other thing, it's not, what I'm saying is it's not that the Muslim groups weren't participating. It's, you got to be smart about who speaks, because on the one hand, basically, the woman from Emerge, I think she did actually testify, but we didn't want a pile-on effect and the problem is that anybody can testify at a hearing, so you can't control what they're going to say, and a lot of people, it's emotional. They don't know how to deal with state legislators, and if you anger a state legislator, he might just vote against you just because he's angry, okay? On the other hand, you got some of the crazies on the other side who are actually coming up and saying, we got to stop Sharia law and whatever, so that inured to our benefit. So it's not that they weren't participating. We were emailing and talking all the time. It's, how are we going to kill this bill? Okay? It's very nice to be like, oh, we should get it. Yeah, I'm all for the diversity and acceptance. That's what we do. But the bottom line is, how does it help you if you get this law in place that is basically codifying anti-Muslim bigotry and then having all these detrimental impacts on other folks too?
But I see your point.
I understand it, but
And we need to push. I'm born in Inglewood, New Jersey, just right across there. I'm American as apple pie. My father served in the U.S. military. I'm going to scream and I'm going to bitch and I'm going to say what is necessary to protect my community. And I take offense that we have to play political correctness games to achieve the goal. Because in the end, that means that our civil society is being undermined. If we're not part and parcel of the fabric of this society, and I could be heard as a Muslim, then even stopping those bills did not effectuate the ultimate objective of making this country a diverse country and everybody's equal before the law. So I agree that we have to maybe have two parallel goals going. One that is focused on pushing that is non-Muslim, because this is not a Muslim issue, it's an issue about our Constitution and our law, and having Muslims being a lot more vocal and not being afraid.
Okay, well, I'm afraid we're at the end of our allotted time. Thank you all so much for coming out this evening. I hope you enjoyed it.